So they've just released this new instrument in relation to the 485 visa extension. This is for people who studied an eligible qualification. So if you studied a bachelor degree, you'll get 4 years instead of 2 years. And if you study an eligible master's degree, you'll get 5 years instead of 3 years. So what you'll need to do is you'll need to make a new application to get this extension. It's listed in this instrument here, and there's no application fee. What work experience can you actually claim in your visa application? So it depends. If it's for general skilled migration, you can only count work experience after your qualification is completed. And even more in New South Wales, you can only count work experience after the date deemed skilled on your skills assessment. However, for something like the employer-sponsored 482 visa, the 2-year work experience requirement can be any time, before or after your qualification. Follow for more migration tips. I'm going to explain in detail the eligibility requirements for the 485 visa extension. Firstly, you must have a 485 visa in the post-study work stream, so you must have studied a bachelor degree or higher. You must be holding a 485 visa on or after the 1st of July 2023. You must have studied a qualification from the eligible qualifications list in Australia. That list has not been finalised yet, but as soon as I get a copy of it, I'll be sharing it with you guys. You'll be able to make this application online. There is no application fee. You do not need to do an English test or provide police checks at this point. You might be required to do a health check, and you must have health insurance. If you provide false or misleading information or even bogus documents to the department, they can refuse your visa and give you a 3-year ban based on PIC 4020. However, there are times when it honestly was a genuine mistake and you didn't mean to provide that information to the department, or you didn't even understand the question to begin with. This happened to one of our clients and we handled the AAT application. We successfully overturned the decision. We used case law, which is called the Trivedi case. The client had unintentionally declared that they had no previous visa refusals, whereas they did, but they didn't actually understand the question. We were able to argue that it was unintentional and was not meant to be misleading. So even though usually to overcome PIC 4020 you need to demonstrate compelling and compassionate circumstances, there are ways that you can argue that PIC 4020 was not even supposed to be enlivened to begin with.